Good afternoon. Welcome everyone. Glad you're still here. Welcome at this final panel of the Cpdp on paternalism. We weren't too paternalistic for a panelist apparently because one of them is lacking still. So on the program is Amber Sinha, but one of his colleagues would replace him. And I emailed with her even yesterday. But Ilona is not in this room, is she? So maybe she will show up later, but if not, then we have still three excellent panelists. So this panel is about paternalism, and we have in the panel to begin with Minke Reijneveld, who published on this very topic in the script at the journal. Walter van Holst, who is working in the field of privacy and data protection for over a decade, maybe 20 years, very long at least, 15, whatever. And one of the prime data protection specialists from the European Union for 1 year still, but then she will be just data protection specialist from the UK, Orla Lynsky. So these are the people in our panel. Then we have a moderator, Tina van der Linden, and I am, you wouldn't expect it, I'm the silent chair, but I'm still talking. But from now on, I will be only doing some administrative matters like time management. So everyone in the panel will have like 10 minutes. And after the 10 minutes, they stop. And after all the panelists have given their presentation, there's discussion also with you in the room on the topic of this panel. So that's the order of events. And we kick off with the moderator, Tina van der Linden, who is a privacy specialist for over 30 years already. So even before privacy was there, she was there. Even before data protection was there. She knows all, she knows everything. And she's our moderator of today. So well, welcome to you all, and I hope you enjoy this panel of this afternoon. And Tina will kick off with, is that? Yeah, that's your presentation, isn't it? Yes.
Yeah. Thanks, Arno. Welcome everyone. Just to set the stage, I would like to make some introductory remarks on the notion of paternalism, because I think it's relevant to see that there are at least 3 ways in which the term paternalism can be understood. Could I have the next slide, please? Yeah. The first is in the sense that Anne Cavoukian used it. And this means giving responsibility of taking care of the interests of the data subjects to controllers, as suggested by the big data authors. So you don't ask the data subject to give permission or to read all the terms and conditions. You just shift responsibility for his or her best interest to the data controllers. That is one notion of paternalism. The second is, well, I think the personal experience of everyone who has ever given privacy a thought. Many of us, privacy advocates, experience this when talking to people who have nothing to hide and just give blanket permission for absolutely everything. And then I'm always inclined to say, no, you should not do that. Do you realize what you're doing, how these personal data may be used against you? And then typically the other person will say, yeah, well, you know, I don't care. A third meaning of paternalism could be government regulation in itself. That is also a way in which the term is used. Finally, I would like to point out that paternalism has a rather negative ring to it. The suggestion is, when you are paternalistic, that you are smarter than the person that you are talking to, or the person that you are talking about, and that you know what is best for them. And of course, privacy has to do with respecting and protecting human dignity. And then paternalism is not something that you would want to be accused of. It has, well, a certain tension to it. Okay, so much for the term paternalism. Let's get over to our panelists. Minke, you have the floor.
Hi everyone. Yeah, it's working. This panel is about paternalism, and I would like to discuss paternalism in the context of the internet. And I will consider this by discussing two different types of profiling. I will begin to discuss self-trackers, then Google, and finally how this is related to paternalism. But to begin, I'd like to start with a statement, which you can already see on the screen. It is perhaps a bit bold, but I would say it is nice to think about it. And although I think there are many counter-arguments against this statement, we could discuss it further afterwards. So I state that instead of regulating the internet in great detail, as the GDPR does, government should aim at creating more awareness and internet wisdom. Well, keep this in mind for later. And now let's first turn to two different examples of profiling. The first concerns self-tracking, which is the topic of my scripted article. Let's take a look at a self-tracking app to see how this self-tracker works. A self-tracker collects data about a person by using a phone or a bracelet. The aim of a self-tracker normally is to improve someone's life, or at least a certain aspect of that life, by, for example, making a person more healthy, more happy, more fit, sleep better. Well, it can be basically any part of your life. Data can either be collected automatically or it has to be fed by the user. Automatic collection is, for example, a footstep tracker, whilst non-automatic self-tracking app is a dietary app where one has to enter manually what he or she eats. A self-tracker analyzes the data it gathers. The self-tracker will therefore gain knowledge about certain behavior of the user through an analysis of the individual's data. This analysis is used to give the user feedback on a number of elements. So let's, for example, take a look at a fitness app. The fitness app, first of all, gives feedback on how far and how fast you have run, how many calories you've burned, etc. And furthermore, the app will analyze data and compare this to different yardsticks. First of all, the app will tell you how well you did in comparison to other users of the app, other users in your specific age category, maybe your friends that use the same app. The app will also tell you how well you did in comparison to your past runs. Were you better than half a year ago? Have you ever before been faster on this specific segment? And moreover, a self-tracker can also compare against a desired goal. So you want to lose 10 pounds, then you really need to run a bit faster because otherwise it's never going to happen. Finally, the app might also collect data about usual routes you take or user profiles. And these data can be sold to, for example, a city planner, a health insurance company, a new supermarket, or any other interested party. Although this might sound as only something which is only for runners, this is not true. It's not only happening within self-trackers. Google, for example, also uses profiling. This is not only to show personalized or targeted advertising to make us sell the most. In addition to this, Google uses special algorithms to show the results that are most likely to fit into your profile of interests. Thus, if you're known by Google as a left-oriented social researcher, this will influence the information Google gives you when you enter a certain search order. Google therefore limits and personalizes your search results. But why is this problematic? What issues can arise when we are all subject to profiling? Profiling has a number of consequences that influence our behavior and may restrict our freedom. First of all, we can be subjected to behavioral targeting. This can be shown in targeted advertising, special prices for a health insurance based on your sports profile, and anything else we can think of. Although some of these consequences might not seem problematic, the consequences can be very severe. Of course, it is good if you get the best deals based on your specific interests. But what if you don't get the best deals because a company knows your profile so well, they expect that you are willing to pay a higher price for a certain product? Profiling can also lead to discrimination. And secondly, we can end up in a filter bubble. When Google only shows us what we want to see or what we will believe, how can we ever realize that there are other opinions or alternative facts available? And for the running app, how can we ever convince people that their behavior is not or is very normal when they are heavily influenced by feedback of their app based on algorithms? I think it's clear now, profiling happens and it has a possible major influence on our behavior. But should a government protect us against this? And if yes, how should that happen? I think that in the current digital world, it is inevitable that profiling happens. Not only can it be useful in certain cases and even necessary in others, it is also just the reality we have to deal with. Companies, governments, research institutes, everyone we know is interested in our personal data, and they will all try to profile us as efficient as possible. This is just the way it is. Therefore, prohibiting the use of profiling is not going to be an answer. This is not going to protect people against influences from the internet in the era of big data. So, something else is needed. So far, the government has tried to regulate. However, one of the premises behind this regulation is that every individual is able to make an informed choice. This is also evident from the cookie debate. The rationale was that cookies would be regulated. However, the obligatory consent implies an almost limitless processing of our personal data. Instead, that we are now no longer being followed, we are now followed by dozens of companies after we give consent for using one specific website or application. And it is a well-known fact that many people cannot be bothered by this at all. They don't read privacy statements, they don't have a clue of the risks that are involved, and they just click OK automatically. Forbidding this would not make sense. It is impossible to regulate this prohibition, and people will just give their consent, and the commercial interests are way too big to create this general prohibition. Therefore, I think another solution is needed. Instead of assuming that people make an informed choice, governments should try to make sure people are able to make an informed choice. This should happen through education. Mandatory privacy awareness classes in primary and secondary schools, and public awareness campaigns comparable to those warning for the risks of tobacco and alcohol. Make people aware of the consequences of their online behavior and how it can backfire. Make sure people know what to expect on the internet. Is this paternalistic? In my view, it is not. The aim is not to tell people what is good for them, but to enable them to make their own choices. Thank you.
It's green, but it's not working. Now it is. Thank you. As you might have noticed, we are joined by Elona, I will pronounce it correctly, Elona Hickok. Now I have it here. Thank you, Lodder. Elona Hickok from the Center for Internet Society of India. We just listened to Minke Reijneveld from the Utrecht University. And I forgot to introduce myself, I think. I'm Arno Lodder. Sorry for not introducing myself. I'm Arno Lodder from SOLV Lawyers Amsterdam and also a professor in the Vrijschrift Amsterdam on internet law. In this panel we will proceed as the people are sitting at the table. So our next speaker is Walter van Holst from, he is the EDRi member Vrijschrift. That's your affiliation as it is on the program, but maybe you will say something else about yourself.
Well, EDRi is world famous in Brussels, but clearly not outside it. It's an umbrella organization of European NGOs in the field of fundamental rights in the digital context, and Vrijschrift happens to be one of the smaller and less prominent members of that. So, but it's quite common for us to affiliate ourselves with EDRi when speaking in Brussels, since EDRi is world famous in Brussels. But since Arno is not from Brussels, he didn't know about that. I've prepared a few slides, but I may diverge from them because Minke's expose is not exactly one I agree with. You have to put it on full screen and so forth. And this has been caused by my failure to use a proprietary file format. I'm using PDF instead of PowerPoint. Oh, you slaves of Microsoft. Yeah, there we go. It's somewhat in the right direction. That's the one. Okay. Well, this is the title of my contribution. Paternalism is the mother of all regulation. I actually was tempted to just toss this one out and leave it at that. But yeah, there's a few thoughts after that. Basically, I'm starting with the textbook definition of paternalism and throw in some perspective. Since this is an academic conference, although I'm here on behalf of civil society and more political, I'm starting with, after that, with a few economic concepts from economics to move on. So, well, this is the Oxford Dictionary definition of paternalism, and it's mostly about limiting other people's freedom based on their supposed interest. And the emphasis on supposed interest is entirely mine, since at the end I will conclude that we may not meet that threshold of supposed. There's a bunch of concepts in economics that are relevant in this context. The first one is bounded rationality, the second one is transaction cost theory, and the last one is network effects. This is relatively recent development in economics. Bounded rationality is a pretty old concept already. It's from Herbert Simon. Basically, he has modeled initially just mathematically, and later on it has been verified by empirical research in psychology. Our freedom to choose, and that ties into what Minke said, how well informed our choices are, and B, regardless of how well informed our choices may be, we still are unable to make choices between a large variety of options. It's more or less a function of IQ and then how the extent you're involved. But you must be a very intelligent person that is very involved with the decision at hand to be able to choose between 9 different options. And we typically end up much lower on that scale. Everything above 5 is actually you're doing pretty well. And given the amount of choices we make, also with regard to, for example, online privacy, on a daily basis, you can imagine that even highly intelligent people are quite often limited to this, let's say, 2 or 3 options they can choose between, if at all, given that a lot of those choices are low involvement. For example, a cookie banner. Click it away. I'm not here for the cookie banner. I'm here to read the article or watch silly cats. So another slightly older concept in economics is transaction cost theory, and it's basically the idea that every economic exchange bears a cost, may bear a cost in itself by negotiating the terms in terms of value being exchanged, but also the other conditions under which it's happened. And it is typically used, for example, to justify trademark law. In trade, we have trademarks for the purpose that, let's say, you want a fizzy beverage with too much sugar, and you're happy to know that Coca-Cola meets your profile of destroying your teeth in a fairly effective way without dying in a too short a fashion, too short a time frame afterwards. So you can mindlessly grab Coca-Cola from the shelf in the supermarket. It smooths out. You don't have to compare between all those unknown brands. And this can be literally quite visceral. I remember swapping for a while, shopping at Aldi. I was jobless, and I was kind of scared by all those nameless brands, or there was nothing I recognized. I literally walked away several times from Aldi the first time because I couldn't really choose. Nothing was familiar. So this is a while ago, but my brain hasn't improved in the meantime. The last one is, and if you apply that to transaction costs for online terms and conditions, the Norwegian Consumer Protection Agency had a very funny experiment 2 years ago, I think, almost 2 years ago. They read aloud all the terms and conditions of the 33 most used apps by Norwegians, and it took them 30 hours to read them aloud. And it's just that, and if you also remember how often those terms and conditions tend to get updated. And as a thought experiment, I have applied a back-of-the-envelope cost of reading terms and conditions. We have 400 million Europeans. We have 85% internet penetration across Europe. Average monthly salary 1,500 euros. Let's say that it will cost 200 euro for every citizen in terms of lost income because you've spent that many hours on reading terms and conditions, and in aggregate you get in a ballpark figure of about 80 billion euros. So if that is of course not a true cost to society of all those long-winded legalese terms and conditions. Oh, 5 minutes, wonderful. Let's move on then. But just an illustration of how fun it is. Network effects is the phenomenon of, this has been brought up in several other panels already, that in certain markets, the more other consumers or the other, on the demand side, other participants in that market are on the demand side, the more valuable the service becomes. The classical example are railroads, slightly less classical, but still very classical example is a telephone. A telephone with whom you can only call yourself is not much of a telephone. The more telephone numbers you can call, the more valuable that telephone service is. And that, the reason I'm bringing this up is in itself has been a pretty important cause for regulatory interventions initially through judicial interventions and later on through the concept of essential facilities. And you could look at Facebook as an essential facility for, let's say, people between 25 and 45. People younger than 25 are on different services like Snapchat and Instagram, and above that it's the old farts on LinkedIn or nothing at all. But still, it results in a market that is a very winner-takes-all one. So these three concepts alone already indicate strongly that we are not the free-willed, independent, rational actors in economy that will do what is best to our own interests and don't need silly things like the GDPR and e-privacy regulation. If you also look at slightly further, it's also about concepts like power differential, fundamental notions of dignity, agency, and non-discrimination, and even more important, then we get into more political philosophy, justice and fairness. You see tremendous value being scooped up based on large-scale data collection, whereas the risks typically end up on the other end of the power spectrum. It's with minorities. Minorities are disproportionately affected by surveillance. Same for low-income groups, and the elderly and the sick. I mean, a fitness tracker is fantastic if you're a highly educated professional, etc. But think about, let's say, you're struggling to be able to afford health insurance, and your health insurance company comes with free fitness tracker included, and you must provide your data to us. That kind of equations, that then you get into the power differential where there's no privacy left for the poor and the downtrodden, to say it in a slightly Marxist way. For the sake of disclosure, I'm a recovering neoliberal myself. So that is, and that gets back to the definition, this supposed interest. I think that interest is empirically provable through various brands of the social sciences. And in conclusion, by virtue of that alone, data protection is not paternalistic at all. It actually adds to your free agency. So that's roughly my conclusion.
Thank you so much, and sorry for being slightly late. I got a little turned around finding the room. And thanks so much for inviting me on this panel. Center for Internet and Society is a think tank based in Bangalore, and we've been working on privacy for a number of years. Now, I kind of have some scattered thoughts for this panel, but to begin with, I think the questions that you posed in the write-up raised two questions in my mind. One, are there critical situations where more paternalism is needed, a more paternalistic approach from a government is needed? For example, in health, and if so, how can these be developed? And is there a way to protect and enable protection of privacy without losing autonomy? Now, those two questions kind of thrown out there. I'll give a little bit of context of India because it's at a really interesting position right now. India is a context with a very large and diverse society. This leads to a wide variety and different notions of privacy. There's been for a while a sentiment in India that Indians or the nation is not a private society. There's also a strong development discourse that runs through India, and sometimes that comes into conflict with the notions of privacy, or that first we'll develop and we'll get roads and then we'll worry about privacy. The Supreme Court of India just upheld privacy as a fundamental right in August 2017, and MIETI has formed an expert committee that is formulating a white paper and recommendations towards a privacy legislation in India. And so in the context of paternalism, we've heard questions of does the Indian government need to take a paternalistic approach in their data protection regulation because of a lack of history and awareness around privacy within the population? And at the same time, we've heard arguments, can we trust the government to actually know what is the right approach and how to best protect our privacy? Now, that said, I think when you generally look at the configuration of privacy, it's been modeled heavily around the notion of consent, and I think that though we need to continue to strengthen consent mechanisms, that also needs to be a shift to other portions, more emphasis on understanding use and clearly defining acceptable uses of data and information that's been collected. There needs to be clear rights, harms, understanding what are the harms that can evolve out of private, what is the range of privacy harms. These can be hard to identify, hard to find remedies for, they can happen many years down the road. And then enforcement of a legislation and the right to privacy, and not only by the regulator but by the user as well, so and the individuals. So what are mechanisms that can be developed to enable users to enforce their privacy rights? And also I think what is important is education, to go back to what you were saying, and I would just add to not only education of the user or the consumer, but also education of companies, developers, and governments. So in all of this, I think what I'm trying to say is that I think there is a way through different mechanisms, through different regulatory instruments, to enable individuals to make choices and to grasp their right to privacy without trying to make that choice for them or limit their autonomy in doing so.
Plenty of time for discussion, which is nice. We already saw different perspectives on the topic. So the mic. So probably on video you can't hear me, but not that important. Let's move on to Lynsky.
Great. Thanks, Arno, and thanks for inviting me to participate on this panel. Effectively, as you might be able to see from our title, I started with the questions that were pitched in the abstract and asked, do we need to be saved from ourselves effectively? Is that what we're talking about when we consider paternalism? And I guess to put it out there from the beginning,
the mic didn't work?
It would work if I turned it on, though. So critical to the presentation. Sorry about that. So asking, do we need to be saved from ourselves? Would be, I guess, the question of, do we need a paternalistic approach to data protection? And in some ways, I would say immediately, yes, we need a paternalistic approach, and rather than focusing on that question in particular, we should almost be at the step beyond that, which is, once we're agreed that we need a paternalistic approach, could we now decide what the best way to be paternalistic is? And I think that ties a little bit in with Minke's presentation, where she said that we should be focusing here on education, or I guess if you're going to use Lessig language, norms. So changing awareness, changing the way individuals think about privacy and data protection in order to achieve more effective protection. But I guess no surprise if you were at the last panel, I would say here that we need, in addition to effective data protection and privacy rules, we also need more structural changes in order to effectively ensure individual rights to data protection and privacy. So I'll just run you briefly through my kind of thinking or how I got to that conclusion. So first of all, I do think that the discussion on paternalism is particularly interesting in the data protection context, because I think it illustrates a kind of an internal conflict in data protection law. So, and I've laid out these arguments more extensively in my PhD work and also in the book, The Foundations of EU Data Protection Law. But in essence, I think you could say that there is a type of tension manifest in Article 8 of the EU Charter of Fundamental Rights, which is that on the one hand, it does seek to give individuals more control over their personal data, and therefore could be looked at as promoting autonomy. And yet, it also strives, and you see this in the case law of the ECJ, for instance, to ensure that those rights are effective. So then if you come back to Walter's presentation and also some of the things that Minke mentioned, you see that there are challenges to the effectiveness of that right. And I'll come back to that. But you might say here, what role does human dignity then have to play in balancing that tension between, on the one hand, trying to give individuals more control through things like consent, through things like data subject rights, like the right to delete, the right to data portability, more obviously, and effectiveness. Well, here, to be honest, I don't think human dignity is of any help at all, insofar as it's quite a malleable concept, and I think it could be argued either way, depending on the ingenuity of the lawyers you have advocating on your behalf. And I think the dwarf throwing case from France is quite a good but old example of this. So should a dwarf be allowed to be launched out of a cannon as a way of earning a crust in a way that he consents to and argues promotes his own dignity because he's able to be self-sufficient and have an independent income? According to the French courts, that was contrary to his human dignity and autonomy. So you could see here that a court took the interpretation of human dignity that promoted a broader public good rather than simply the interests of the individual. And I personally believe that data protection and privacy do not simply protect the individual, but they also protect a broader societal good, and therefore that human dignity can't really be decisive. So what are the consequences of this? Well, first of all, I think individual autonomy has a role to play in data protection law, but it's a starting point rather than an ending point. So that means that we do, in data protection regulation, acknowledge lots of incursions on individual decision making. For instance, when you're allowed to process personal data in the public interest, or when your vital interests are at play and you're unable to manifest or to transmit or communicate a decision. So we've lots of legal bases for personal data processing that don't actually directly involve the individual, which already recognizes that we're posing limits. So we do have this paternalistic regime. Should we have a paternalistic regime? I would say yes, again, because of the practical limitations to that individual autonomy, such as the issue of bounded rationality that has already been mentioned, but also because there are normative limits to that autonomy. There are points in time when we might, for instance, want to process personal data to facilitate freedom of expression. So with that in mind, and I recognize that a lot of that is contestable, but with that in mind, I think then the question becomes, how could we make data protection rules more effective for the individual, and how can we look at the context of the decision making in order, as we've just heard, to facilitate individual choice to the extent possible, but to also make the general context more privacy or data protection friendly. And I think it's here that we kind of see problems at present. So I've just pointed to 2 or 3 things that I think are issues which perhaps we might come back to in discussions. So first of all, I think there's a weak culture of enforcement. This data, which is not very scientific because we don't have very many cases on data protection yet before the Court of Justice, but this has been published in an EUI working paper on the role of civil society in enforcing data protection law. And what I would say, if you just pick out a few statistics there, is that so far we only have 6 cases before the Court of Justice involving data protection authorities enforcing data protection rights. So the individual here, if because of practical and normative constraints, if the individual can't exercise their own rights, essentially I'm saying that there's nobody there in the background to help them really exercise their rights. You've had very few preliminary reference, very little case law here, so a weak culture of enforcement so far. This could be improved by the GDPR, and I know that there's a lot of emphasis on administrative fines, but really here I think probably the most critical provision in the GDPR from this perspective is the ability it grants to civil society organizations and non-profit making bodies to take actions on behalf of data subjects when they are given a mandate to do so. And I know at national level, one of the big kind of fighting grounds at present is whether or not civil society organizations can take those actions without mandate. And you might say again that the ability to take that action without mandate is quite paternalistic, but that has to, I think, be traded off with the idea that often for individuals, they will not be in a situation to identify when their rights have been violated, and the ecosystem that they're facing is a very complex one. I know I get lots of push notifications from Google. I know I have my location turned off in my Android operating system phone, and even with a bit of digging and a bit of expertise in the area, I'm unable to prevent those push notifications completely. Should I be left out to dry, or should there be a civil society organization that can put that case for me before a court or before a regulatory authority? And then finally, and this links clearly what was discussed in the last panel, I think here, rather than going down the data protection as paternalistic route because it doesn't facilitate individual autonomy, I think we should be trying to change the discourse to say, rather than focusing on the individual, how do we make this better for the collective? And again there, one thing we could do is to tackle data power. So consolidations of data in the hands of a small group of actors, which then eventually become, or effectively become, I guess what in economic discourse would be called unavoidable trading partners. So from an economic perspective, you might say an individual, it is paternalistic not to acknowledge that an individual has agreed to Facebook's terms and conditions. If they're using Facebook, then it is paternalistic to not recognize that choice. However, as the German Competition Authority is now starting to come around to the idea, when there is no alternative choice, can we really say that there is individual free will at play? And so I guess that's one final query for the audience and other panelists is, can we talk about free choice and avoiding paternalism here, when in reality we are faced with these consolidations of power and very little effective choice?
Wow, thank you. I think we are doing quite good time-wise. We have half an hour left, I think, for discussion. So is there any member of the audience who would like to ask a question or share a comment with the panelists? Yes, there's one.
Thank you. Thanks for this very interesting panel. My name is Claudia Quelle, and I'm a PhD student at the Tilburg Institute for Law, Technology and Society. And I've been thinking a bit about paternalism myself as well in my research. And I think, Orla, the way in which you've put it now is really, really powerful, and I do think we should also look towards the collective issues and the general level of protection that should be facilitated. But my question to you is, how do you think that relates to the choice, individual choices, and the choice architecture that you've previously emphasized in your work? Thank you.
So thanks for the question. I think it relates because in essence at the moment, from a data protection perspective, I think we have kind of come to a collective conclusion that relying only on individual choice mechanisms doesn't work. But I think if you look at neighbouring fields of law that are still very relevant to the way in which personal data are processed, they have yet to come to that realization. And so if I'm to think of an example here, a couple of years ago, the UK Competition and Markets Authority did a general survey on the use of data in for certain consumer practices. And so it looked at things like video games and advertising and a few other areas, and looked at whether or not that market was functioning well for consumers. And so kind of a general health audit of that sector. And after a couple of 100 pages of analysis, it effectively came to the conclusion that the market would work well for consumers if they were better informed. However, if you look at, so, you know, that was kind of the grand revelation at the end of all of these years of work. But I think most data protection advocates would look and say, well, there's been a Data Protection Act in place in the UK since 1984, quite fittingly, and it is information forcing, so forcing you to provide this information to consumers. And if that hasn't led to a change and to a healthy market, why would we suddenly expect that to occur now when things are becoming more and more complicated? So in essence here, it would be, I can acknowledge that if you allowed, for instance, a consumer protection organisation, so Which in the UK is becoming quite active in this area. So if you allowed Which to take an action, that there was a representative action for data subjects or for individuals, there might be some individuals who were happy with the deal that they were given, or who were kind of didn't really care either way. But I think we need to now start talking about data protection and privacy, not simply in individual terms, but also as a collective good, like an environmental harm. And you know, that analogy has been made for years, but I think it's quite a powerful one. So even if some people are happy with bad air quality in London, others don't have the choice. And so, and everybody's decisions will impact the general environment. And so, but as I said, that's tricky in the data protection context, just because it's pitched as an individual right, and because informational self-determination and individual control are kind of wrapped up in that right. But I think we're already saying they're not absolute elements of the right, and so we need to kind of start to pitch this as a collective good, and then say, as a collective good, it needs a range of mechanisms to protect it, rather than simply putting all of our eggs in the data protection basket.
Thanks. Next question, yeah.
Hi, I'm Dennis Hirsch. I'm from Ohio State Law School in the United States. I was delighted to see this panel. I think this is a really important topic. And I'll start, I'll just make a kind of provocative statement, or maybe not so provocative in this crowd, and then also ask a question. But the statement is, I think, for all the reasons that the second speaker and others of you have mentioned, consent, notice, purpose limitation are largely an illusion in our system of regulation. And if it takes 30 hours to read through all the terms and conditions, it's an illusion that you are actually consenting in any kind of free way. I think it's an illusion that both those who advocate for privacy have an interest in furthering, because it shows that they are doing something effective. It's an illusion that the business community has an interest in furthering, because they can say they're doing something to protect privacy. And it's really pretty easy, actually, to comply with these types of requirements. What would be really harder would be, as a society, to develop substantive norms and ideas and values for how we think data should be processed and how we think it shouldn't. What's appropriate, what's inappropriate, what's okay, what's not okay, and draw some of those substantive lines. And that's the question of, you know, one of the pushbacks against that is, well, that's paternalistic, we can't be paternalistic. And that's why I was so glad to see this panel. My question is, and I teach at a law school, under EU law, existing EU law, do you think that there are opportunities to legally draw some of those substantive lines? How would you do that within the GDPR framework? Is it legally possible to do that? I've heard some people talk about, you know, processing has to be fair and lawful. Can you kind of get into what's fair or what's not? I've heard some people talk about the legitimate interest test and notions of, you know, kind of what's appropriate and what's not. But I'm interested to our panel, if you were going to try and do some substantive paternalistic regulation through data protection law, would that be possible, and if so, how?
I'm actually a bit surprised by that question, since we have, ever since 1981, which is quite a while ago, the OECD guidelines, which already recognized notions of fairness, lawfulness, and most important, proportionality. And I don't really care which way you fall in the debate, whether I can consent to online cross-site tracking or not. I don't believe I can. I agree with Minke in that respect, that you cannot possibly give your consent there. I think it's quite telling that even the ICO, which in a climate of not overly eager enforcement of data protection rules is considered one of the least hawkish DPAs traditionally, was agreed with the other DPAs that this is kind of an example of that it cannot possibly be proportionate. So even if you believe you can get consent for that, post-consent you still have to do proportionate data processing. And the idea that Google is having embedded through Google Analytics and other beacons on the top 5 million websites is following all traffic on the top 5 million websites. And that's just Google. I have no specific hatred to Google, but that one player can follow us, look over our shoulder, how much time we spent on sports news or on porn, or what passages of the Quran are our favorites, at what locations. That is a very chilling thought. We've created our own omniscient gods into some respect, and they're residing in Silicon Valley, and at the same time as sinful as the Greek pantheon. So good luck with that.
No doubt someone wants to comment on this. Yeah, Orla?
Well, sorry, I think that's a very good question, which is, you know, why don't we have these clear-cut rules? And I think when you look at the transition from the Data Protection Directive to the GDPR, you see that GDPR is now a lot more prescriptive than the Data Protection Directive, but we still don't have very clear-cut, bright-line rules on what is permissible and not. And I think the trade-off, and I guess the rationale for that is then it's ostensibly future-proof, and that it can kind of move with the time slightly and is easy to fit to different processing practices. But clearly the disadvantage of that is that there's quite a lot of legal uncertainty then about what is lawful and what is not. But I think if you're going to go for that kind of open-ended general regime for data protection, then it's crucial that you have adequate enforcement of the rules. And one of the reasons why we can't say what is a fair practice and what is an unfair practice is because we have no jurisprudence on that question from the Court of Justice, but also, and I know there are others in the room that have done research on this, very little at national level in the EU. And the concept of fairness is culturally specific. It's different in different legal systems across the EU. For instance, if I look at Ireland or the UK, then they tend to be quite libertarian in their perspective when it comes to what type of contracts, consumer contracts, for instance, you can sign, as opposed to more protective systems. So I do think that's interesting that, you know, we don't have anything to fill into that category of what is fair and unfair. So it's been in the books, or on the books, since 1981, but I would say we're still not really much wiser as to what exactly it means.
This notion that fairness is culturally specific is, of course, a nice question to you, I think. I don't know if you're aware of the European discussion in the context of the GDPR, but is it different in India? Can you tell us something about fairness in data protection or in dealing with personal data, how that in India differs from the discussions here? Or is that an impossible question?
I would say that it's a standard that does not find itself in the current regime around data protection in India. So we have, or there are standards under the Information Technology Act, which lay out a quasi data protection framework for body corporate, and they don't adopt a framework of fairness within them, as the fairness being a standard for the processing. So would I say there's a comparison? I would not say immediately.
Well, if there is no standard of fairness, but there must be something like, well, if you give permission for something, like the dwarf throwing example, are you free to give permission for anything, even if that is to your own detriment?
That, I think it depends on the context that you look in. In the rules, the consent mechanism, if I understand correctly, that's what you're asking about, is that the consent is taken from the individual before taking or collecting sensitive personal information.
Yeah, okay, thanks. Yeah, another question there.
Hi everyone, my name is Grégoire Delette. I work for the French DP organization. I was wondering what your thoughts are on perhaps another form of paternalism, which is, let's say, international paternalism by the EU, in the sense that adequacy decision, for example, or even everything that is related to data flows, it comes at sometimes at the expense for the country to abide by our values that we have decided democratically, and which is fine, but we also have a soft power, which is a very normative power outside of Europe. And I was wondering, how do you think we can cope with that? And is there any way we can make it better for, let's say, like small countries which want to do commerce with the EU and which have to abide by those rules? Thank you.
Any volunteers? Walter?
Okay. Very briefly, there have been pretty global attitudes research towards attitudes among citizens. I'm not a consumer or a user, but a citizen. And they tend to travel rather well across cultural boundaries in terms of how comfortable people are. I would also like to point out that half of this panel has been about notions of free will, a theological problem we haven't solved in Christian theology since the medieval ages. But at the same time, data protection fits in rather well with, let's say, Eastern Asian cultural notions of honor and shame. And I'm sure there are other compatible notions in other cultures like that. So in a way, for something that is supposedly a Western imperialist liberal dogma, it seems to transfer rather well across cultural boundaries.
Can if I understood your question correctly, was it about the territorial scope of the GDPR? That the GDPR imposes its norms on all kind of companies outside the European Union that are now working very hard to be compliant with the GDPR? So, it's an interesting question. Maybe someone wants to reply on.
It is another interesting question. I do think the EU is leaving itself quite open to accusations of paternalism or perhaps even imperialism with the adequacy regime and with that kind of effectively the fact that third countries need to have a carbon copy of the EU rules in order to be deemed adequate. And I think that, I do wonder what impact, I'll mention the B word, I do wonder what impact Brexit will have on that. Not just in terms of whether it might mark a turning point insofar as you might have some sort of Western alignment, at least against the notion of adequacy and the adequacy framework. So I don't know to what extent, for instance, the UK might align with the US and with other Five Eyes partners like Australia and New Zealand in order to push back slightly more against the EU on the adequacy perspective. And I think you might also hear query, or some have queried, whether or not the Court of Justice could be looked at as paternalistic in the context of data protection, insofar as if you look at things like Opinion 115 on the PNR agreement, it is effectively tying the hands of Parliament and Council when it comes to the agreement of international treaties in the data protection sphere by laying down very detailed criteria that need to be fulfilled in order for international agreements to meet EU human rights standards. And so I don't know whether it's right to think of that as paternalism or some sort of impact on the de facto separation of powers within the EU. But I think you could think of this vis-a-vis third countries, but also between EU institutions and EU member states.
Yeah, I think it is indeed a very interesting point that the GDPR, but other data protection regulations and everything as well, is not only paternalistic towards citizens within the European Union, but also towards companies and towards citizens outside the European Union, which indeed poses other questions like, do we want the European Union to pose such consequences for citizens who are not part of the European Union? Do we expect companies or people outside the European Union to consider themselves bound by these rules, and do we expect people to be willing to be bound by these rules? These are, I think, important questions regarding paternalism, which indeed go farther than whether or not we as a government or a government should protect people, its own citizens. It is about whether or not governments can bind other citizens or other companies. So it is a very interesting addition to the debate, I think.
Okay, so we have at least two more notions of paternalism that are relevant in the context of data protection.
Maybe I can add, because I forgot. In the announcement there was some wrong quotation, because the paternalism quote in the announcement was about paternalism from the perspective of the company. That if the company has to take care of the data protection norms, then the company is sort of paternalistic towards the data subject. So that's yet another angle to the paternalism debate. That's an erratum I was forgetting to tell you at the beginning.
Okay, any more questions or concerns or opinions or thoughts that you like to share with us? Anyone from the panel who wants to have a final word? We've said enough. Well, just from my own part, a final observation that this spillover effect of European data protection regulation is of course inherent in the borderless nature of the internet. If you want to regulate anything that takes place on the internet, these spillover effects are well, inevitable. And I would say that if as a company you want to earn money by providing services to European users, then it's only fair that you abide by European rules. Even if that may be a bit paternalistic, nothing wrong with some paternalism, I would say.
Wait,
Okay.
I have a question because we have some time left and it's a waste to not spend it on a topic. I have a question for all the panelists. Do you think that the GDPR is capable of protecting the data subjects towards processing of data that is not in their interest? Do you think that the GDPR, because that's one of the aims, do you think it's fit for that purpose, or that maybe it's an illusion, like some already said in the 90s, that Ethan Katz, for instance, privacy on the internet is an illusion. What do you think about, does it make sense still that we have this GDPR in the context of internet, and will it, can it fulfill its role from a paternalistic perspective? Would be interesting to hear from the panelists.
I would say it's a step in the right direction. In the early stage of the consultations before the GDPR, I managed to get EDRi, because it was early in the game, to advocate a horizontal minimum mandatory punitive damage. It was a very modest proposal, €10 per data subject in cases of data breaches. The idea is, and that's why I quite like the fine ceiling of 4% of global turnover, plus the ability, at least in some member states, of collective redress. You are putting in, until now, all the big data snake oil peddlers have always been talking about the golden mountains beyond the horizon in case you are into big data. It's only about the upside risk. Having a potential downside risk, even in a lax enforcement climate of 4% of your global turnover, ends up pitting the marketeers against the bean counters that tell them, well, you can do this, but then you must guarantee us at least a profit of, let's say, 5 to 6% of global turnover to compensate this potential fine of 4% of our global turnover. Make your business case or go home. And that alters the conversations, especially in large corporations, sufficiently that I think it will probably be change of the game. Whether it will be sufficient, that's only time can tell.
Yeah, I think I agree to that indeed. The GDPR is a good try, I would say, and it can solve issues, but other issues, well, we have already seen some issues, and other issues are also likely to arise when the GDPR finally comes into force, and when we see what effects will occur and what will actually happen with the GDPR in practice. So I think it looks promising, but still we have to see how it works.
The companies really are capable to account for what they're doing, confirm Article 5, subsection 2. That's an interesting question, of course. So the principles we were talking about from 1980 are still in the GDPR, of course. And now the controllers have an active duty to demonstrate that are compliant with those principles, which wasn't there before. So that's an interesting addition to the current framework.
Actually, quickly to jump back to the discussion on jurisdictional reach of the GDPR, it's interesting because in the dialogue around privacy in India, EU adequacy has played a role, particularly in the IT sector. There's been a push for stronger and interoperable, or a stronger and interoperable framework, so to enable trade and easier trade with Europe. But actually, it's been very largely driven by a debate around the Aadhaar scheme, the digital identity scheme in India. And the Supreme Court ruling goes into a number of different spheres of privacy, including dignity and the home and women's privacy in making their choices. So I think it's interesting that, yes, on one hand, the GDPR does have a very clear impact on business, but on privacy as a contextual and a societal issue, I think that's very specific to a country and how they shape it. On the GDPR, if it's adequate. I think that the GDPR does a good job in defining the rights of the individual, and they have built upon and defined some important new rights for the individual to have.
You want to add something? No? Okay. What about the audience? Do you feel that the GDPR is effective in protecting our rights? Who thinks the GDPR is effective? It is a good idea. I see some hesitating hands. And who thinks it's not effective at all? Not a good idea?
It's not enforced yet.
Okay. No, but we can make a prediction. You can have an opinion. Yeah. Okay, anything else? Okay, then on that note, I would like to close this panel. Thank you all for coming. Thanks to all the panelists. And let's go to the drinks.